the judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Good morning, everybody. Please be seated. Welcome to the United States Court of Appeals for the Fourth Circuit. We have two cases on for hearing this morning. First is 25-1128, Public Interest Legal Foundation versus Knapp. Ms. Green, or Mr. Green, sorry. Whenever you're ready.
Thank you, Your Honor. Good morning, and may it please the court. My name is Tracy Green. I'm representing the appellant, which I'll refer to as the commission or the election commission. I would note that on the caption, Howard Knapp is listed as the executive director. That actually now is Jenny Wooten, who is the interim executive director of the commission, which was a recent change. I would note that for the record, but we can also send a letter to the court to the clerk if the court would prefer on that point. The underlying issue in this appeal is whether Section 8I of the NVRA, the National Voter Registration Act, entitles this foundation as a non-South Carolina voter to receive a list of South Carolina voters that a state statute limits restriction only to South Carolina registered voters. The district court ruled that the foundation is entitled to the voter list and that state statute is preempted by Section 8I of the NVRA. I'll refer to it as with that acronym. The commission respectfully submits that the district court erred, but on appeal, the commission further raises the issue that the foundation did not have standing to present that claim, and therefore the case should be dismissed because they do not have standing. I'll address the standing issues first, followed by the remaining substantive issues, and will rely on my brief for any issues that I don't reach today.
So the district court didn't reach the standing issue?
The district court did not reach the standing issue,
And it's
Your Honor.
at the summary judgment stage?
That is correct. We were at the summary judgment stage. We filed cross motions for summary judgment. We didn't press the standing in part of our summary judgment at that level. We did raise it in our complaint, both as answers to their allegations.
It sounds like you have much of a choice when you're talking standing. We have to look at that.
The court does have to look at it. The court always has to ensure itself of its jurisdiction. I just want to be clear. We did not press it beyond the pleadings or beyond our responses to allegations and
Is
the
that
like at
because,
that
I'm sorry,
stage.
is that because you didn't think, you thought that the foundation had standing?
We have evaluated it differently at different times, I would say, Your Honor. And we started briefing this case before Hippocratic medicine came out. We went back and looked at things after Hippocratic medicine. As you noted in the Republican Party case, Hippocratic medicine seems to really tighten things up on organizations. And so we took another look at it and we decided to raise the allegation and push it more. And so the long story short is I think Hippocratic medicine sort of focused us in on what needed to be done, and we decided we didn't think they'd crossed that threshold.
I'm really interested in the procedural posture of the case because if nothing was done at the district court and all you have and all we have is a complaint, and I don't think the complaint is verified, is it?
It is not a verified complaint, no, Your Honor. There's a verified complaint and there's an answer. There were stipulations of fact filed and agreed upon stipulations of fact
Most
filed.
of these cases we see come on a 12B6 dismissal or a
Yes, sir.
question on standing, but when you get to summary judgment, I'm wondering what can we do with it? Do we just send it back and say consider standing, or what if you never raised it? I mean, what if nobody picked up on it? It's confusing at this point that it comes to us after a summary judgment. If it was 12B6, it'd be something different. We can look at the complaint, the allegations, that sort of thing. But the case law is pretty explicit that when it gets to summary judgment, you have to have some evidence, affidavit or something there to support it, and there's nothing in the record of sorts. So what do we do with this thing?
There is nothing to support it. We understand that. We would submit that under,
But now, practicality. If we
Practicality.
If we send it back, I would think, I know the Third Circuit has felt differently than others, but they probably could find, something to get, at least for the informational injury, and then you got the greater questions on this downstream stuff that we may have a conflict here. There are a lot of little small issues in this case that really doesn't go to the merits. At the end of the day, if they're able to establish standards, that's a pretty strong case, but go ahead. I just want to, we can talk all day long about all this other stuff, but those procedural issues and the issues are right there in front of us, and what do we do with it? I mean, do we now listen to you for the next 20 minutes, just go on, knowing at the end of the day, there's really no, if we do address standing, there's no evidence at this point. So what can we do other than send it back?
Your Honor, I would submit that it is their burden to prove standing at the complaint stage. Their allegations do not get them across that threshold, and nothing else that was done, either by affidavit, again, and I don't want to overrepresent
Allegations are
what
not
we did.
evidence is what I'm saying at summary judgment. So that's understood.
Right, but
But it just seems like something is missing, that it just comes to us now because they could have done these things. Nobody brought it up.
No, sir, nobody brought it up. I don't want to overrepresent that. But I do think the standing has to exist at the time the complaint is filed. Their allegations we submit are not enough to get them across that threshold. And there was nothing else that was introduced or adduced either in the stipulations or otherwise in the arguments that would give them same. In fact, I would say.
If it's an allegation, it's not anything that can get them across. It's not just not enough. It's not evidence. The complaint was verified, then we could treat it as evidence, but it's not evidence. So that's my point, is you saying not enough. We can keep talking about what the allegations are all day long, but the question is it evidence to support a determination of standing at summary judgment, or do we look back at the 12B6?
I think on this point, you would look back at the 12B6 because it's their burden to get into court, and they did not allege enough.
Okay.
And that would be, and I would add one thing to that, Your Honor. You could consider, I think, as part of the arguments and discussions, they conceded that they could get the voter list otherwise. I think that would go to their injury, in fact, and the concreteness of it. So I think there are things that you can consider as part of that process. So
We do have case law, cases in which the issue of standing was raised for the first time on appeal, and we sent it back in a summary judgment context. We sent it back for discovery, for jurisdictional discovery. Would you have an objection to our doing that?
I would prefer not to, Your Honor. My argument would be that you can hear, it's their burden to get in on the on the complaint level to allege facts that would support a standing argument. We submit that under the precedent that we've cited in our brief, they've not done that. But candidly, that is an option for the court. I can't deny that. It would just be our preference not to. Thank you, Your Honor. I do want to touch briefly on the standing issues, if I may, before I proceed to the substantive. I mean, putting aside what I understand Judge Wynn's points, and putting aside that, I think there's a question about what analysis should be applied here, and we would submit that it's along the lines of the Spokio, Dreer, TransUnion, and Hippocratic Oath cases. The foundation has contended that lawfare affords it standing just by virtue of the fact it is alleged an informational injury. We submit that that is not the allegation or that is not the analysis that should be applied here, because TransUnion held that an asserted informational injury that causes no adverse effects cannot satisfy Article 3. I think Dreer anticipated or presupposed or got TransUnion right a long time ahead. And so therefore, because there's no common law analog for a statutory informational injury, the foundation has to show it suffered a real world harm. And we submit that they've not done that here.
That's issue is not as straightforward with us, because I think there's a conflict in our law on this downstream consequences. It arises from that Lawford case and early treatment of dry and TransUnion, the interpretation of it, the whole bit. And the question is, you know, is that a part of the analysis, the downstream consequences? It's not straightforward to us at this point because we do, I mean, that, you know, I read Lawford and I tried to reconcile it with the other one. It's spot on. And saying, you know, the conflict is spot on. I mean, it's right there. Those two cases conflict.
Lawford and Dreer?
Yes,
Yes, Your Honor.
no question.
No,
So, but the later one we have is Lawford, but typically on these, we look at the earlier one. And it may have some consequences here, because we don't have that information of the downstream consequences.
Yes, Your Honor. I would submit, no, I have struggled to come up with an easy reconciliation of the two cases, and I have not been able to do something like that. But what I would say is that I think Dreer applies here for several reasons, beyond the fact that it was the first one decided. I think after Hippocratic medicine, you have to look at what the organization has alleged. They can't allege just diversion of resources. That's not enough, because they can't just kind of sort of what Hippocratic medicine says, and what some of the other decisions say. They can't just go around looking for causes of actions to sue the government for, to complain about something they've done. I think the organizational standing here is their problem. The diversion of resources doesn't work for the same reason, Your Honor. Hippocratic medicine has tightened that up, I think, pretty substantially. And they don't have, essentially their allegations are, put aside the diversion of resources, they're going to talk to somebody somewhere, sometime about the voter list or about voting things in general. We submit that's not concrete enough, and that's not specific enough.
I'm sorry to interrupt, but isn't that the reason why they exist? I mean, that's the whole purpose of the foundation, is to engage in that kind of activity. So why isn't it reasonable for us to assume that that is likely to happen, that kind of interaction with voters?
Because I don't think that's what Spokio or Dreer or TransUnion talk about. It has to be specific, concrete allegations. And I would add to this, I think Twombly and Iqbal require more specific factual allegations than just, we'll use this information somehow. It's got to be more specific about what they'll do with it. I would say,
You know, I guess it just seems odd that a state elector, I guess it's not a citizen, but it would be a state elector that would have access to this information, or all South Carolina?
state elector.
Okay,
Somebody who can vote.
okay, right. So just as a general principle, someone who can vote would have access, but an organization that's committed to ensuring the integrity of the electoral process can't have access?
That's correct.
Does that make sense to you?
I think it does, Your Honor, because it's really, it ties more into the focus of the statute, which is providing information, frankly, to voters about whether their registrations have been properly handled and the like. And the people who are interested in that are South Carolina voters. So to tie that back into a standing analysis, and I think the Third and the Sixth Circuits in the decisions we've cited in our brief thought that significant, that the foundation is not part of those states because they're not helping a voter in those states. There's nothing there. I think that would distinguish this too a little bit from the Republican Party case against the North Carolina Board. That's in North Carolina doing North Carolina things. And there's a specific injury there. Here, there's no specific injury for any South Carolina person.
Wouldn't your theory then preclude standing in every FOIA case?
I would distinguish a general information. Let me make two responses to that. I don't know under the current law what the status of it is for a pure informational statute like FOIA. I don't think this is a FOIA-type statute because it is part of Section 8, only part of Section 8 of the entire National Voting Rights Act. So it's just targeted to Section 8 activities.
It provides for disclosure of information. So
It does.
it's one part of it, it's not the whole part of it. Is that the difference?
It is not the whole part. It
That
might
doesn't
be
seem
different.
to go to Article 3 standing.
Yeah, Your Honor, that's, I think, our position. It might be different if it were its own standalone statute, section 15, within the NVRA, but it's not.
Why, from a constitutional standpoint, would that be different?
I think because TransUnion, Dreer, Spokane, you have to look at the type of harm that Congress intended. They can create causes of action and the like, but there's still got to be an Article III injury to get into court. And it's got to, if there's not a traditional remedy at common law, it's got to be tied to the, harm that Congress sought to remedy. Now, maybe there's nothing to do with the foundation talking or giving out information. It's not like they're doing something like Project Vote where there are specific voters. There were questions about their voting or registrations, excuse me, and their activities were targeted to that. That was concrete and specific. That is not what we have here. It's just generalized allegation. Frankly, a generalized grievance that would be shared with any non-South Carolina citizen. It would be like somebody in Alaska wanting to talk to their neighbor about South Carolina's voter list. That's not enough. We don't submit. I will rely on, unless there are other questions, I will rely on my brief and respond to anything in rebuttal.
Thank you, Mr. Green.
Thank you very much.
Ms. Valdez?
Good morning. My name is Carolyn Valdez, and I represent the Public Interest Legal Foundation in this case. Mr. Chief Judge, and may it please the court. The South Carolina Election Commission asks this court to revisit issues already resolved by Congress and already decided by both this court in Project Vote v. Long and the Supreme Court in Arizona v. Intertribal Council of Arizona. The NVRA includes a broad public disclosure provision that requires states make available for public inspection.
What about the standing issue?
The standing issue is quite frankly not an issue in this case. And to address some of your questions about the conflict between,
You don't mean not an issue from the perspective that we have to determine if there's standing here, if it
Yes.
comes to us. Even if the district court didn't consider it, we have to assure there was standing.
yes, I meant only that it's not an issue because the foundation does have standing.
And you're at a summary judgment stage, and you have evidence that you submitted that would support this?
Yes, we have
What is the evidence?
we have stipulated to all the facts necessary to resolve the standing issue.
Stipulation doesn't address injuries. You
Well-
address a lot of things in it, but there aren't specific injuries necessary to establish standing. In your stipulation, I looked at it very carefully, because I'm trying to find it too, because, I'm just thinking as a matter of practicality, it'd be nice to be able to do it. I'm wondering, can we do it at summary judgment? Your complaint is not verified. The stipulation doesn't include information about injuries. It has a lot of other things in it. So, what do we do with it? It's problematic when a case comes to us like this, and looks like it could be a delay, but I don't know how we avoid it.
Well, because this is an informational injury, all that's required to establish standing is that the plaintiff failed to obtain information that must be publicly disclosed pursuant to a statute.
So there don't need to be downstream consequences shown?
No, not under this circuit's precedent in Lawfer, as well as the Supreme Court's precedent in Public Citizen and Aikens.
Lawford conflicted with an earlier case we had that said it did require the trial case. It's on point, it says it. And I grant you, Lawford says it too. I don't know what to do with it. And then you got TransUnion, which, one could look at that and say, that's true too. I think it's something, I don't know if we can resolve it as a panel, because we can't conflict with the earlier panel on it, but that was true of Lawford. It could not conflict with the earlier case too. I don't know how you distinguish the two cases.
The injuries in those cases are distinct. So in Dreyer, the injury was inaccurate information, which is more in line with the Spokio line of decisions. Lawfer, on the other hand, was a failure to obtain information required to be publicly disclosed pursuant to a statute. And that's the injury that we have in this case. So it's completely different injuries, and so the cases don't conflict. And I would urge this court to follow Lawfer to find that the foundation does have standing in this case.
So we're not bound by other circuit precedent, but you made those arguments in at least two circuits that I'm aware of, and they rejected them. Why were they wrong?
They were wrong because they misapplied TransUnion, and this circuit applied it correctly. This circuit in Lawford talked about how TransUnion distinguished Public Citizen and Akins. It did not overrule them or call into question their holdings. And Public Citizen and Akins definitively hold that all that is required for an informational injury is a denial of information required to be made public by statute.
Let's say we disagree with you and think that our earlier precedent, as well as the Third and Sixth Circuit analyses of the law is correct, and that is you need something more than simply informational injury. Is there something more in this record that you can point to?
I can only point to the stipulated facts, and again, I would just urge that.
But do you think that's enough? And if so, tell me why you think that's enough to satisfy that slightly, well, I guess, more significant burden.
I would say that, to your point, this is an organization dedicated to protecting election integrity, and using this information is right in line with what this foundation does. I think to the extent this court would like more information, we're happy to supplement. But again, I would just point to the fact.
I guess I don't know that we can supplement on appeal. I guess the case would have to go back for jurisdictional discovery, but I know you don't want that. So I'll ask you again, do you think there's enough in this record to satisfy that stricter burden? And if so, point to me where that information is.
I'm not sure I can say that it satisfies the stricter burden.
Okay.
But I would just reaffirm that that stricter burden is not what applies
That's
in this
fair.
case.
I understand that. Okay.
You know, you've had other cases like this, and the issue of standing, you've addressed that in other cases. I'm just wondering, when it goes to the district court, did it occur to you that standing would come up on appeal? I mean, the burden is for you to establish standing, but as I see it, nothing was said to the district court about it. And it would seem to me, you would say to the district court, well, Your Honor, I want to ensure we have standing, here's an affidavit, or we can take the complaint and we can, verify it or whatever is necessary, and that is evident. That would be some evidence in the record. But I don't see anything in those stipulations tell me what in that stipulation addresses injuries.
Well, again, I would point to the injury is the denial of the information that must be made public pursuant to a statute. And based on that injury, the foundation doesn't need to allege anymore or provide affidavits.
In other words, per se, you get standing as a matter of course based upon the statute, is your opinion.
Yes, because that's
But
what
if
Congress
you take
decided.
the position that Judge Diaz just articulated, you don't get it in that instance if you have to show some downstream consequences or something of that nature based upon the early case from this court and maybe interpretation of TransUnion by other circuits and perhaps our interpretation. Right? I mean, you don't get it with just that naked statement that is information that we should get.
Under the theory that downstream consequences are required, no,
You wouldn't get it in. But I even evidentiary with that, I'm just thinking in terms of evidence. You still have to have specific evidence without downstream. And there's no specific evidence that's being offered. I know it's painful to say these kind of things, but I'm sort of troubled by the fact that you're not new to these cases, and you've had them before. You had to know standing is an issue in these cases, and yet the district court didn't address it. Nobody brought it up, and then you come to us, and now we're talking standing. And that's not, I know you like to supplement evidence and stuff. We don't make those findings here. In fact, we pretty much, as a blanket, we don't do that. We send it back to the district court, and I realize, the timing of it is troubling to me, because I'm not sure the outcome is going to be any different if you do, one way or the other. But, okay, well, I think it's frustrating at this point. And as I said, we can talk on and on, but that issue is right there in front of us. And I don't know what we do with it. I don't know how we resolve it, except to send it back.
I would just still point to the fact that we did stipulate to the evidence that is necessary to make a finding on standing in this case.
What is that evidence that you stipulated to?
That we were denied the voter list, which is the information that Congress made
That's-
public
that's
pursuant
what
to
happened.
statute.
You were denied the voter list, but what is the injury?
That is the injury. That's the informational injury. Just like it was in Aikens, Public Citizen, and Lawfer. All that's required is the denial of the injury itself, because Congress made that information available to the public.
It goes back to TransUnion and what we think of those cases. I think I see where you're going with it. It's not as clear to us as I would like it to be.
In your complaint, you do have several allegations in your unverified complaint about, I think, what could constitute, if there were facts to support the allegations, could constitute potentially downstream injury if we were to find that that was necessary, or if that was what the case law demanded. For example, in several paragraphs, you talk about the organization providing policy advice, legislative guidance in South Carolina, specifically aiding South Carolina in carrying out list maintenance, maintaining institutional knowledge. I mean, you do have allegations, and so I would assume that an opportunity to provide some evidence to support those allegations would be welcome.
Yes, absolutely. And if this court were to find that downstream consequences are required, we no doubt have downstream consequences from the denial of the information, and would be happy to compile affidavits to that effect.
And what do you mentioned a number of cases, but you didn't, the most recent case from the Supreme Court, I think, to speak on this issue is the Hippocratic medicine case, which was after all the cases you were talking about. So what do we do with the requirement there that seems to require downstream consequences?
Well, again, that case involved a completely different injury. In fact, the Supreme Court said the associations had not claimed an informational injury, and that is what we're claiming in this case. So I think it's a completely different set of facts, a different injury in that case. I would also point to what you had mentioned earlier, Judge Berner, about how you were asking if FOIA is distinguishable from this, and I would argue it's not. In fact, the Supreme Court in Public Citizen used FOIA as an example where there is a pure informational injury just by nature of not receiving information that Congress made public. And in Public Citizen, the statute at issue was not a general public disclosure statute. It was a part of a statute, similar to how the NVRA, the public disclosure provision, is a part of a whole. So it's really not distinguishable from the FOIA context, this theory or this informational injury. And to the Commission's argument that potentially part of the injury is that we could get the information another way, federal rights do not exist by proxy, and so that should not impact the standing analysis in this case.
I think related to that, the commission is arguing that not only could you get the information in a different way, but that the statutes are directed at protecting South Carolina voters and information related to South Carolina voters, and you are sort of an interloper coming in from the outside to gather information that really is none of your business. And I hate to be that blunt, but how do you respond to that?
I would argue it is the foundation's business. I mean, this is an organization dedicated to protecting the election integrity, and the foundation does that by analyzing state voter lists for missing information, duplicates, and the foundation is able to present that information to the states, which allows the states to take that information and better protect their own constituents. I would also argue that South Carolina's statute does not protect a whole group of people that would be interested in this information, and that is South Carolina voters or South Carolina citizens whose voter applications were rejected. Under the South Carolina statute, those citizens would not be able to request the list and inspect it for widespread rejection processes that might not be in line with the Constitution. And those people do have a vested interest. So this case goes beyond just the foundation. This is an exercise in good governance for states and transparency and accountability that is crucial to the functioning of this democracy.
It is an interesting point, though, that South Carolina would want one of its citizens who's registered to be a party to it, when there's someone who's outside, not in having South Carolina's interest at all. They're looking to comb through the records, and there may be nuances that an elected person may want to be involved in it. And, you know, when you think about state rights, federal rights, which we used to talk about a lot, seems like now we're talking mostly federal rights, and life is going in a different direction. But when you think about that, the state of South Carolina wants to, they say you can have this list. You just need to get one of our voters, registered voters, probably got 1 million or more, millions there. It only take one of them. And I don't know how much they got to be involved in it, maybe, or your organization, it's not a membership organization, is it?
No, it is not.
So, but you have constituents, I guess, you have some other, it's an organization in which, I'm just wondering how difficult it will be to align a registered voter to get the list. I mean, with millions out there, probably sharing your same aim, your same views, everything. And I'm wondering if, even if you had one of your directors or someone who was a South Carolina one, you could just temporarily vote them up there, I guess. Say, there's a member, we got a member, this member is a South Carolina person. I'm not sure that would work, but it just seems so simple that if you really want this list, you could get it. But you don't want to have to go through, you don't like this law that says I got to do it with a registered voter.
Well, federal rights don't exist by proxy, and so the fact that we could have access to the list through other means is not relevant to the issue at hand. And I would also point to—
But it does mean you can get the list, and that's what Congress wanted you to say. You can get this list. South Carolina adds a restriction on, I mean, another restriction got on it. Congress didn't say you got to pay for that list. South Carolina makes you pay for it. I guess you're not challenging that aspect of it. So it's a degree of restriction, and maybe you can't get it, even though the statute says you must get it. But they say, no, you can give me $2,500. It seems like it's kind of the same thing. They say, no, you got to get one of our voters to be part of this deal here. And there are millions you can select from, and you haven't shown any indication you can't get one of those millions to do it.
I would argue the residency requirement is not the same thing as a fee. And that is because the residency requirement that South Carolina has poses an obstacle to Congress's intent in enacting the NVRA. Congress
But the
intended—
issue here really isn't a federal right. The issue is Article III standing, which Congress can't create. So I don't think the question is whether there's a violation of a right. The question is whether you can bring this case in federal court. I'm wondering if you can address the decision from this court from almost exactly a year ago today in the RNC case where standing was found. Is that case, is there anything there that, are you alleging facts similar to that case?
I think we are alleging facts similar to that case. And I think the standing issue in this case is really more simple than is being presented today. I would just go back to the fact that TransUnion did not overrule Public Citizen and Akins. And those two cases definitively hold that all that is required when you have an informational injury is a denial of information that Congress made public. Congress made this information public. Congress decided that this information was to be available to anyone, and South Carolina's attempt to restrict that and limit that poses an obstacle to Congress's intent. And that is where standing is found in this case.
Do you have anything else, Ms. Valdez?
I would just urge the court to find standing in this case based on the stipulated facts and this court's own decision in Lawfer, as well as the Supreme Court's decisions in Public Citizen and Akins.
Thank you very much. Mr. Green?
Just very briefly, hit a few points there, I think all of which are covered in our brief. In no particular, Judge Berman, your decision in the Republican case, I think there were more specific allegations that are going to Article III standing than there are here. And frankly, it had to deal with voting issues and a political party that does voting. So I think it was more specific than it is here.
It was also a different procedural posture.
Different procedural posture, that's true. So, but I think, and.
Yeah, but even there, I was, at least, and I recall I wrote separately suggesting that there was some doubt about the nature of the information there. It seemed a bit ambiguous, generalized, but in the panel's view, just enough to get over the hump, at least in my view. So I mean, I think you need something more, but I do want you to respond to Ms. Valdez's point that, Congress did create this statute. I think it was intended to maximize disclosure. And it seems almost counterintuitive that a foundation dedicated to this very work, the work of election and election integrity and voter rights, is somehow barred from the very information that Congress thought was important for the public to have access to. You see the sort of the inconsistency there in the way we handle these kinds of cases?
There's certainly the courts are struggling with the not entirely clear messages from the Supreme Court that relate to informational standing, Your Honor. I would sort of tie this one into the language in Hippocratic medicine, which I think you noted also in your concurrence in the Republican Party case about, organizations don't get standing just because they go around opining on legal issues. And courts don't respond on legal issues in response to citizens who roam the country in search of governmental wrongdoing. That seems to be more the case here.
That's a general proposition that I think that's accurate, but in the face of a statute that says you do get to search these records because Congress has spoken and said that citizens and/or organizations do have access. That's not an organization roaming the countryside looking unsolicited for information, but someone trying to enforce their rights in federal court. And maybe it comes back to Judge Berner's question, and that is, is this the forum for the enforcement of that right, or is there another forum?
Yes, but Your Honor, I respond to that one way, which is I think their allegations about the harm they've suffered do involve them kind of going around checking up on what the government's doing. So there is something to say that is what they're trying to do. I would also, and again, I get the tension, but I think they do have to show something more than they've showed with what they're going to do with that information to establish an Article III injury.
Well, in RNC, we talked about having to divert funds, and in the Phelps complaint, they talk about the need to expend additional resources and staff, including limiting funding for other pending investigations and programming. In RNC, we talk about communicating with registered voters and organizational and voter outreach efforts. I think almost the exact same language is in the complaint here. So it seems to me that the allegations, at least in the complaint, which is unverified and there are no facts to back it up, but track pretty closely the allegations of the RNC in the RNC case, which was found sufficient to establish standing.
Well, I would say a couple things that I think they have alleged sort of legal conclusions about their standing, which is not sufficient, I think, to get them across the threshold, whereas I think the allegations in the Republican case, as I read it, were a little bit stronger and a little bit more specific, more about what they were going to do and the issues in general, specific. Here, it's just a generalized allegation about they can't get the vote list, and they may do something with it sometime, somewhere. And I respectfully submit, that's not enough. I think even if you look at Public Citizen and Akins, I think those cases, and Dreer did interpret them this way, there actually were downstream consequences alleged there. And I would also note in Public Citizen, the disclosure about this was a bigger deal, and it actually incorporated that Freedom of Information Act, whereas that's not the case here. We've got a narrow statute within Section 8, which is about the voter list information, and no other structure about how that goes. So,
All right, thank you, Mr.
thank
Green.
you, thank you.
I want to thank you and Ms. Valdez for your fine arguments this morning. We'll come down and greet you and move on to our second case. Our second case, 24-2143, McPherson versus Patton. Ms. Horn.
Good morning. May it please the court. My name is Gail Horn, and I'm here on behalf of the plaintiff appellants who are also present in court. This case is about the wrongful conviction of two innocent men. As the district court noted in its opinion, there is substantial evidence of their innocence in the record. They had multiple alibi witnesses who testified on their behalf, and the state of Maryland has declared them innocent. One of the primary pieces of evidence that was used to convict my clients was the taped police statement of Marcus King. And just to put it into perspective, Marcus King at the time was a 13-year-old with very limited capacity. Contemporaneous evaluations of Marcus demonstrated that his IQ was in the low to mid 50s and that he had the reading comprehension of a first grader. He recanted on the stand. He testified under oath, subject to cross-examination during trial, which was contemporaneously recorded. And he explained—
So he was killed in 2000, and now you only have his statement of that time that you want to get in, and the trial court made a decision not to allow it in, but you think it should have been allowed in.
That's correct, Your Honor. We think that it was an abuse of discretion for the court to refuse to permit that testimony to come in under Rule 804B1.
That's a pretty high burden. I mean, you've got to show that the ruling was essentially irrational, unreasonable, contrary to the law, and not just that the judge might have gotten it wrong, or even if we might have ruled differently, I don't think that gets you there. So what is it about this ruling that meets that very high burden?
Yes, Your Honor. There were 3 clear errors of fact on which the district court based its opinion. And a clear error of fact, using that as a basis for a decision, is an abuse of discretion. So she said there were 3 reasons why there was no similar motive. The first was that the prosecutor was shocked by the recantation of Marcus on the stand and that she didn't have time to prepare her cross-examination. That is directly contradicted by the record. Marcus recanted in November, just a couple of months after he gave his statement to evaluators who were evaluating him in connection with his juvenile proceedings. He recanted again to a state's attorney investigator, and the prosecutor disclosed that in an amended disclosure. He even recanted on the way to trial. Detective Patton picked him up to take him to court the first day of trial, and he told Detective Patton, according to Detective Patton's own testimony, that what he said on the tape was a lie, and that Mr. McPherson and Mr. Simmons had nothing to do with the crime. Ms. Holback, the prosecutor in this case, gave a deposition. In her deposition, she said, "I wasn't surprised by the recantation. I knew about the prior recantations, and witnesses flip-flop all the time. What I was shocked by was his calm and cool demeanor in making this recantation." So it was clear error for the district court to say, Holback, the prosecutor, was shocked by this recantation and could not prepare. That's not supported. That's directly contradicted by the record.
Okay, but that error has to have had an impact on the ultimate decision. And so how did it impact the decision?
Well, she said these were the three, so that was one of her
Okay.
3 bases. She had 2 other bases. Her second basis was, it was a reasonable strategy. Once the court sua sponte said, hey, you can get in Marcus's police statement, it was reasonable for her to cut her losses and get Marcus off the stand. In theory, maybe that would be a reasonable strategy. That was not the strategy of the prosecutor in this case. In this case, she nearly doubled her cross-examination. She went into all kinds of topics, not just clarifying what he had previously said, but attacking the recantation. Who made you say what when? Who exactly was the person who told you to say this? Didn't you have your Miranda rights given to you? Wasn't your mother present? So regardless of whether it would be a reasonable strategy, it was not the prosecutor's strategy in this case. So that's the second basis that she used. It's also directly contradicted by the record. The last basis that she said made it so that there was no similar motive was that the prosecutor did not have any need to either defend Defendant Patton's credibility or the integrity of the investigation. That's also not borne out by the record. The record directly contradicts that. She asked questions of Marcus, the ones I just mentioned, about was he given his Miranda rights, was his mom there? She asked questions of Detective Patton to try to explain the coercion. He said, oh, I only put on handcuffs and leg irons for Marcus's safety. I only yelled at him because I wanted him to understand it was important, it was a serious situation. And most importantly, she said, isn't what he told you new, as in information you didn't provide to him, he provided to you, and he said, yes, some of it was new. And if there were any doubt that what she was after was to defend Patton and defend the integrity of the investigation, her closing sealed the deal. In her closing, she said Marcus gave his police statement not because he was given a script by the police, but because Defendant Patton got through to him in that moment. She applauded Defendant Patton for his integrity, for his intelligence, for his professionalism, and for his investigation that led to the wrongful conviction of my client. So that's the third basis that the judge used, and it's also clear error. So when you pick it apart and you look at the reasons why she used it, I appreciate abuse of discretion is a high standard, but we've met it here because each of the bases that she used was a clear error. It was directly contradicted by the record.
So you've got to apply then those, what facts might be competent in this case to the question of whether or not she had a substantially similar motive to rehabilitate the detective. Is that right in this case with respect to fabrication?
Well, that was her claim, was that in fact the prosecutor did not have a similar
Right.
motive to rehabilitate the detective. But there's ample evidence in the record that that's exactly what she was doing. Think about it. This is one of her star witnesses. He's getting on the stand saying, the police made me lie out of my mouth. I kept telling them.
Right, but the district court, as I understood it, and you can correct me if I'm wrong, concluded that really the prosecutor's principal motive here was to rehabilitate the witness, not necessarily the detective. What do you find incorrect about that?
Because I don't think she had a motive to rehabilitate the witness, but she also had a motive to rehabilitate the detective and defend the integrity of the police investigation. And that included eliciting testimony from Marcus, that he received his Miranda warnings, that his mother was present, that he wasn't mistreated by Patton when he picked him up and took him to court. It also included eliciting testimony from Patton about receiving his Miranda warnings, that he was only handcuffed for his safety, that his mother understood the charges, and that he yelled to just convey the gravity of the situation. And I pulled a quote from the closing argument where this all kind of comes together and you can really see what her trial strategy was. She says, not only am I not gonna apologize for Detective Patton's banging on the table, but I applaud him, ladies and gentlemen. And she goes on later to say, he's a diligent, intelligent, professional, dedicated human being who wanted to solve this murder, and solve it he did. And she goes on, and she says, I applaud him for that. She says, Marcus confessed, quote, not because he was tortured, not because he was beaten over the head with a phone book like they did in other places, but because he decided that what he had done was terribly wrong, and Detective Patton got through to him for that moment in time. So you can see from the evidence.
What about the trial court's admonition that the courtroom, that trial was not the place to criticize or analyze the detective's conduct in this case? Is that somehow relevant to this issue?
Well, I mean, unfortunately or fortunately, that was what was on trial in part, because what Marcus said to the jury was not only is this a lie, but the police made me say it. The police were yelling at me. The police were hollering at me. And in fact, Detective Patton said that he did all of those things. He said, I banged on the table. I stood on the desk. I yelled at him. I told him, we're not leaving here until you tell me the truth. And by the way, when the defendants said, oh, well, that means he couldn't have been coercing him, he couldn't have been fabricating him, what he meant and what Detective Patton testified at the criminal trial was the truth was what Diane Bailey told him, not some abstract concept of what might have actually happened.
So in the face of two motivations, and is the test that they have to be, that they essentially have to be the same, equal, some one motive more than the other? How do we look at that?
I think that Supermarket of Marlinton answers that question. You look at the motives to see if they were similar. And even in Supermarket of Marlinton, the motives were not identical. In the criminal case, the court said the motive was to prove that there was no conspiracy. In the civil case, the court admitted there were two motives. It was not just to prove that there was no conspiracy. It was also to prove that if there were a conspiracy, there was no element of fraudulent concealment involved in that conspiracy, so that the statute of limitations would run on the claim. And that, I would say, is analogous to the situation. There's always going to be multiple motives. This is a complex murder case. The prosecutor doesn't have a singular interest as she's litigating and prosecuting the case. Her interest is, of course, to get Marcus's police statement in, to make sure that the jury appreciates, or she tried to defend the veracity of that statement. But it's also, she has to rehabilitate Detective Patton. She has to defend the investigation, because otherwise she's left him out to dry. And this Marcus, that's one of her key witnesses. That's the only way they can corroborate Diane Bailey.
Could I ask you another question about the fabrication claim? So there's two elements to that. First is you have to prove that the investigator fabricated evidence, and second, that fabrication resulted in a deprivation of the plaintiff's liberty. Now, obviously, the district court never reached that second element. So if we agree with you on the first prong of that test, what do we do about the second prong?
The deprivation of his liberty?
Yes.
I would submit, Your Honor, that Marcus's the false police statement that was attempted to introduce through Marcus and ultimately introduced through Detective Patton, did in fact deprive my clients of their liberty.
Well, do we get to decide that in the first instance, or would you send it back to the district court?
I think that's a jury question, frankly. I think there's
Okay.
sufficient evidence in the record to say that when you introduce false evidence, fabricated evidence from a detective, well, first of all, that can never be harmless. But regardless, there's sufficient evidence in this record to say that causation question.
So we send it back for a trial, is what you're saying?
Yes, Your Honor.
Okay.
Yes, Your Honor. I believe that the fabrication claim, there is sufficient evidence. A lot of what the district court did in this particular case was take the facts. Well, first of all, the district court didn't consider Marcus's trial testimony, and that obviously alone warrants a trial in this case. But even once that's considered, or even when you look at the other aspects, what the district court did and what the defendants want you to do in this case is take all the facts and all the inferences from those facts in their favor. They want you to weigh the evidence. But here, this is a classic case of a dispute of fact that warrants a trial on the fabrication
So
claim.
regardless of whether we agree with you on the issue of the proper application of the hearsay rule, it's your contention that we should still reverse summary judgment on the fabrication claim?
Yes, Your Honor. I think that there is sufficient evidence in the record. Obviously, it's a much stronger claim if we can have Marcus's testimony admitted at trial. And I think even if you don't agree under 804B1, 807 is also applicable in this particular instance. We cited some case law in our brief.
How could that be? I mean, you just indicated earlier that Mr. King was all over the place. I mean, the most unreliable of witnesses, and yet 807B requires significant evidence of trustworthiness of the statement. Those are completely contradictory.
Well, the requirement in 807 is for trustworthiness is a surrogate for in-court examination. We've cited U.S. v. Shaw, which specifically says that. And in this case, the trustworthiness surrounds the circumstances under which he gave it. He gave it under oath in front of a jury. He was subject to extensive cross-examination. In fact, I think his entire exam was ultimately cross-examination because he recanted.
So we only look at that particular instance? We don't look at the other circumstances?
Well, you also look at the rule specifically instructs, and the district court failed to do this, the rule specifically instructs to look at the corroborating evidence. And there is substantial corroborating evidence for his recantation in this case. And it's not just going to the innocence of the plaintiffs. Obviously, that exists. But it's also about what happened in that interrogation room. Detective Patton admits to a number of the things that he did that Marcus testified to. He admits to banging. He admits to yelling at him. He admits to feeding him information about the guns. The sole culpability of Marcus is that he went and allegedly got these guns and brought them back and handed them to the shooters. Detective Patton admits, yeah, I told him all that information. I gave him all that information. His mother is another piece of corroborating information about what happened in the interrogation room. She testified, she couldn't remember everything, obviously, 30 years later, but she does testify that it was so coercive, so oppressive, that she thought her son was being physically threatened, she thought her son was forced to lie, and she had to remove herself from the interrogation room. So I think if you look at the circumstances under which Marcus's testimony was given, and you look at the corroborating evidence for the testimony itself, I think that it does satisfy Rule 807. And I think that one of the things to remember is although Marcus was a less than perfect 13-year-old witness, again with some limited capacity, he was firm. He was firm that the people who told him that it was Eric and JR, Mr. Simmons and Mr. McPherson, was the policeman, the white detective. The policeman made me say this out of my mouth.
Before you sit down, I want to ask you a question about your second claim regarding the suppression of evidence, and in particular, the contention that you may have forfeited the issue of materiality because you simply sort of wave at it in a footnote. Can you address that?
Your Honor, I think you're referring to the bad faith.
Yes, sorry. Yeah.
Yes, Your Honor.
Bad faith. Did I say materiality? Sorry.
It's a long morning.
Yeah, well,
We did.
Not as long as usual, but go ahead.
We did reference bad faith. It was not an issue that the district court reached or had to reach in its opinion. We did reference it in the footnote, and the defendants were able to respond to it. And the defendant's response to our argument was that this court in a footnote in Owens said that bad faith cannot be inferred from the value of the evidence that was withheld. That is not what that footnote says. That footnote actually says some circuits require bad faith, some circuits don't require bad faith. The Fourth Circuit is a circuit that requires bad faith. And the courts have been able to and have inferred bad faith from the value of the evidence. That is, that the evidence was so material that no reasonable officer would not have disclosed it. It couldn't be an accident. It couldn't be negligence. And I would submit that the evidence in this case is of that ilk, because we have two witnesses who completely refute what Diane Bailey says. They say there was one shooter, and one of the witnesses even says, I can identify who that shooter is. That information was not disclosed to the plaintiffs for them to be able to use in their case. And what the district court said was, well, it wouldn't really be material or favorable because each witness who was out there saw just a piece of the puzzle. I would submit that is taking the evidence in the light most favorable to the defendants. That was actually what Detective Patton testified to. That is literally his story. But if you look closely at what was withheld and you take the procedural posture of summary judgment at its value, what you can infer is none of these witnesses, Sandra Jackson or James Martin, they don't see 5 people running up the street the way Diane Bailey described it, and they don't see 5 people running back down the street. They see one shooter at the corner of Federal and Washington, and Sandra Jackson says, I can identify that shooter. So the plaintiffs could have put on a completely different case. It's not a conspiracy, it's not a big group shooting, it's one person, and it's not them.
All right, thank you very much.
Thank you.
Mr. Redmond.
May it please the court, I'm Michael Redmond on behalf of appellees Detective Robert Patton and Detective Frank Barlow. First, I'd like to correct a couple of misrepresentations that counsel just made. First, as far as as far as the corroboration issue, the mother of Mr. King, her actual testimony on JA 8544 was that she never saw the detective feed King facts. On 8545, that she never saw them lay hands on King or threaten to lay hands on him. And at 8552, that she does not know whether King's recorded statement was true or false, even today. Also, other corroboration information that is in the record includes Mr. McPherson's in custody confession to a psychological evaluator, where he expressly said that he didn't directly shoot him, but he was part of the conspiracy, where he corroborated, his story corroborated exactly what the recorded statement by King was and exactly what Ms. Bailey's testimony was, that he one day the stick-up boy was spotted and I told my little man to go get the guns, and beyond directly saying exactly what the story was there, he also gave details about Mr. Wooten lying on the ground shaking as he was suffering from his gunshot wound. So the overall corroborating thing does not at all suggest trustworthiness as of Mr. King's recantation. Also,
Well, let me ask you this. The defendants were declared innocent. Doesn't that mean the statement was false?
no, Your Honor. That means that the state cannot make them guilty.
I mean,
That was a criminal
declaration of innocence is what I'm saying. A declaration of innocence, a factual declaration, I think. I don't think it's a legal thing. If you pardon or you get clemency, that's one thing, but to say you are, I take the word as actually innocent on it, doesn't it by definition say there was something false in that trial?
No, Your Honor, it does not. And that is not at all in any way binding on this civil trial, where the defendants here were no party to those proceedings. They are not the state. They had no ability to intercede in those proceedings whatsoever. That is in no way binding. Here, we start from a blank slate. The plaintiffs are required to meet their burdens, which is exactly what they did not do here. We
Well,
cannot
I think we're at a
assume.
summary judgment stage. How do we view this evidence?
Oh, we view it in light most favorable to the plaintiffs, but that is exactly what was done here by the district court. It's just that what the appellants claim would be the light most favorable, what are reasonable inferences, what they call reasonable inferences, are actually speculation. they try to argue that things that would actually be speculation that don't actually have a rational basis for eliminating other possibilities, that is an inference available to a jury when it is not.
Let me ask you this. They were convicted and spent how many years in prison?
I believe over 20.
So over 20 years, and during that 20 years, I guess about 5 years ago, King was killed. But it appears, at least in the light most favorable, they shouldn't have been in prison in the first instance, much less 20-plus years. And also in the light most favorable, they are there because of the detectives having done something. I mean, it can't be that they were in prison for no reason, that the detectives had nothing to do with it, and yet there's a declaration of innocence that they are in prison. Just hear me out. They're in prison for this period of time. But had it been 10 years ago, King would have been living, and you could use the statement. But they are there wrongfully in prison, and because they are wrongfully in prison until it finally comes up, they're innocent. They are punished for being in prison because they don't have the benefit of King's testimony because he's killed in 2020. And it just seems sort of maybe perverse in some ways that individuals who are declared to be innocent, declared that. I support that. They didn't have to do that. They let him out, but didn't have to take that next step and say you're innocent factually. Hit on it. But I'm concerned, and maybe it doesn't have to go to the real issue, but there is something there that differentiates it from other cases where witnesses are not available. And it's as though you can't bring this action because no one has come forth with any evidence. The evidence or the reasons for you being here hasn't come forth to now finally, for want of another term, you probably don't like it, vindicate them, so to speak. But you do agree they should not have been in prison based upon what the state determined.
No, Your Honor, I don't.
Do you think they should have spent 20 years, even though the state says they were not, they were innocent?
Yes, we were not a party to the state's proceedings. Basically, the judge in those, and it's called a writ of actual innocence. That's just what the procedure for letting people out is called.
The question of, you're not a party to put them there either. The state put him there. The state said they were guilty. The state did that. You don't get to, it's not a question of whether you think they're actually innocent. You don't really matter on that. It's a question of, does the state that put them there say they are actually innocent? That's a term of art that's come out now quite a bit. It's a differentiation from clemency, pardon, or forgiveness on any level. But when you get to actual innocence, that's a factual determination. Is it not?
No, Your Honor, not in this case. In this case, Your Honor, the state's attorney.
But I want to know what is the determination of actual innocence in the state? You're telling me that does not mean the state said you are factually innocent. You saying that?
No, Your Honor, it does not mean that under Maryland law.
And where is that stated?
What I don't have the statute before me, but what
You're saying the statute says it does not mean that you are actually innocent.
No, what is required in the statute is that there's supposed to be new evidence. The judge found that there was not new evidence, but because the state was asking for them to be let out anyway, they said, okay, well, we're not, nobody's contesting it, so we're gonna let it go. What the statute, I believe, requires is that there be some kind of evidence leaning towards or suggesting actual evidence. Not that there's not a contested, here there wasn't, and there often is not a contested disputation that is resolved by a judge that yes, these people are actually innocent. They're simply meeting a standard that there's some evidence that might suggest actual innocence. That is, I believe, all that the statute requires. It certainly does not require an actual determination of innocence, and even if it did, this is a separate civil proceeding where the state is not a party. The state is not being sued here. The state cannot, so these two detectives cannot be held in some kind of res judicata or estoppel posture. This is simply a brand-new situation where the plaintiffs have to prove all their facts, have to produce evidence that actually shows their facts, and that's what they did not do here. So, does that answer your? Yes.
Getting to the hearsay question, because you seem to suggest that this is a brand-new case, but it's obviously deeply interlinked with the criminal proceeding.
Yes.
And, as I understand your formulation of the hearsay rule or what was applied, it seems I can't imagine a circumstance in which testimony in a criminal trial could ever be admissible at a later civil trial, because under your formulation, the motive is always different. Is that not?
No, Your Honor. Sometimes it meshes up, sometimes it does not. That's, I believe, what the district court held, and she gave evidence, gave an explanation as to why, in this case, there did seem to be a significant dissimilarity in motive. I think the really important, the important issue, the threshold where you're going at is this a fair substitute, is the type of cross-examination that happened, or that there was a motive to happen, is it a fair substitute for what a defense counsel would be able to do, or would be motivated to do?
Well, the burden of proof in the government is higher in the criminal context, and so it seems there would be a strong motive in the criminal context, and there's no requirement of privity between in terms of the predecessor and interest. There doesn't need to be any privity. So
No.
wouldn't it be enough then,
No, when you actually
the
look.
motive? Wouldn't it be similar enough?
Not here, Your Honor, because of what they're trying to use this testimony to do, which is, when you look at what they're actually asking the court to do, is to look at this testimony, to look at the testimony to try to create an inference that the 17-page recorded statement was fed to them, that it was fabricated, that all these details, that 17 pages worth of details, were actually fed to Mr. King rather than.
Well, I think that would be the jury question. The jury question would be, did that happen? But I think what's being asked for here is simply to let that in.
Well, yes, Your Honor. Sorry, what they're trying to get an inference of that from a statement, from the trial statement, which did actually explicitly said that did not happen. When he was asked, when he said, yeah, they may be.
So then why wouldn't you want it to come in?
What?
If he explicitly said that in the trial statement, why wouldn't you want to bring that evidence forward?
Well, then once it comes forward, then there becomes more issues. It's still, we argue and believe it's correct that even if it is in, we still prevail. We still, because
And you may yet prevail if it goes to trial, but the question is whether it comes in or not, and the question on whether it comes in is whether there was a sufficiently similar motive at trial.
And to try to explain, to answer your question exactly, Your Honor, the actual testimony at trial said when Mr. King was expressly asked, okay, who told you? Did the police officers tell you all these details? No, they didn't say all these details. Who told you what to say on the tape? And the answer was, nobody told me. Pressed a little bit, there's some section, okay, Whitey I got the information from, but not from the police officers. There was never anything that said the police officers gave me this information. It was just, they told me to keep telling the truth. They kept on disbelieving my assertions of innocence. There's nothing that they actually fed any details. So what they're trying to say is that even though there's a direct statement that it wasn't, that they didn't feed them details, that there can be an inference from this that somehow all these details came from the police officers, and that's exactly what a civil defense attorney right now would want to go into and make sure that 17 pages of all these details. How many guns, did they tell you that, how many guns you got? Did they tell you who took the guns? Did they tell you, what color the bag was? Did they tell you all these different things that he said, all this information that he provided? Did they tell you each one of those things? If we had Mr. King available for testimony, we could cross-examine him to that and absolutely dispel any notion that there's a possibility of an inference of these things from his testimony. But we can't do that because he is not available. And the prosecutor had absolutely no motive to do that, because the idea that someone would say, yes, even though this testimony explicitly disclaims them feeding you these facts, there's an inference of it, that's not something that was even conceivable at the trial. That's not something that was in the prosecutor's mind at all. In fact, if the prosecutor were to go through all the details in front of the jury to get all that information out, that would actually be harmful, or could possibly be harmful to the idea of trying to advance this as a corroboration of Bailey's testimony, because some of the details that were allegedly fed by the officers are actually, contradict some of the things Bailey said. I think like the number of guns, things like that.
Mr. Redmond,
Yes.
sorry to interrupt you. I asked Ms. Horn when she got up about the standard of review and the difficult burden that she has, and that's to your advantage. And she responded, I think quite ably, by suggesting at least 3 factual errors that she thought the district court made that were clearly erroneous. Do you remember that?
Yes.
Can you explain to me why, if you can, why she's wrong about that?
Yes, because she is largely misrepresenting the record.
Well,
there-
better to say maybe misstate.
Sorry. Yeah, I believe we disagree with what the record actually
If she did,
entails.
and I'm not suggesting
And-
that she did. So
and,
so tell me what she got wrong.
Okay, first of all, the idea that that the prosecutor wasn't surprised, the question, the distinction that she made, the actual pages that she cites, says yes, she was surprised. Walking in that morning, she had talked to King.
Frankly, I think if any prosecutor would be surprised that the very first witness that she calls or recants on the stand. But Ms. Horn says, well, she shouldn't have been surprised because he was doing it left and right at every turn.
Well, she was, and yes, she.
But why was she?
had
Why do you, go ahead.
But she, in her opening statement, she said, Marcus King is going to tell you exactly that he went to go get the bag of guns. That was in her opening statement, that was going to happen. Likewise, the other, I'm trying to recall exactly what the other points that she made.
Well, I think she said the prosecutor had no motive because her principal motive, that the motives weren't necessarily exclusive. There were more than one. She had every motive to try to rehabilitate these officers. And in closing, she made the arguments that in fact suggested that her motive was equally to rehabilitate the officers.
Yes, and the closing, of course, is actually largely irrelevant because it's not actual the cross-examination. It's taking whatever it is she got during the trial and trying to put the best picture on it. The question is more, what were the questions actually asked during cross-examination? What were the motives that she had, the motive and opportunity that she had at the time in the heat of the moment? And I think a discussion of all the details that a civil defense lawyer trying to dispel this notion of an inference contrary to what was actually said, all those things are the things that the prosecutor clearly did not have a motive to try to dispel. And
What are the questions, or what more would the prosecutor have asked if there was a similar motive? What would she have asked in addition to what was done at trial?
So did they say that you needed to say that 4 people were involved? Did they say which 4? Did they tell you to say you went to Alfred's house at the specific address you mentioned. Did they tell you to say that you found the guns in Alfred's bedroom closet, that you saw 4 but only brought 2, and that the types that you mentioned? Did they tell you to say that appellants already had guns,
So
but others
these
took
are
them?
questions you're saying she should have asked?
Yes.
And, I mean, you're prosecuting a case, and you going down the line of everything and get this witness to say every one of those things they told me? Think
No.
about what I'm saying on it. Think about it. Is that really in the best interest for them to do that? Or to simply have him to say, well, they put words in my mouth, and they said it in a general way? It would seem to me, from the officer's perspective and the prosecutor's perspective, you do not want it to be specific information. That's what a defense counsel is going to do. Get up and do what you just said, because you don't want this witness to gain credibility by keep asking these questions. The more you ask and the deeper you get into it, how does that help?
Because
The detective, you think he's going to say no?
That's what he said to the general question. Did they tell you to say what to put on the tape? He said no. Yes, I think that he would say, no, they didn't tell me this specific thing. They didn't tell me that specific thing, because he said generally they didn't. But of course, it's not in the interest of the prosecutor to go down all these things for exactly the reason you said.
We're talking about a young man, a young fellow who has clear intellectual disabilities. I know his mother has testified, but she too had a drug problem, and she left out, said she couldn't stay in that room because she couldn't take it, what was going on. He's shackled at the table there with these officers. No one's in there, and you got a great gap in terms of this interview that's going on here. And he's saying, they put words. He tells me they put words. He said, and the recantation when it started, he didn't change that now. Apparently, he did it early on, and he was consistent with that recantation, as I understand, till he passed away in 2000 or whatever. Or is there any indication there's some difference that went from his testimony from that point there?
There's actually is record in the case that, yes, he did actually incriminate Mr. McPherson on page 11880 in an incarcerated statement, or in one of his institutional evaluations that listed that he actually
And
did.
that's under oath? That was under oath?
No, it's not under oath, Your Honor.
But he's under oath. I mean, he's right there on the stand, and you got
Yes.
a prosecutor going at him.
And what he said on the
But
stand.
hear me out.
Sorry.
You got a prosecutor going at him full strength on it, and you want that prosecutor to pick every one of those statements, or go down a statement and say, did he do this? Did he do this? He doesn't need to have done all of them now. It could have been, did you really need to do that? If he says, they put some words in my mouth, I didn't say that, do you really want to go down and pick out every little thing from a prosecutor's perspective? Or do you want to say, well, that's not true, this is true? You can argue. He didn't say that on.
Exactly,
argument.
under that, from a prosecutor's perspective, absolutely, that is the problem.
I'm not sure the detectives would have done any different
The
if they were trying to say that their statement was true. They're
If
not
the-
going to
the
go
de-
and get him to go back and forth on each one of those.
For a civil defense, absolutely, Your Honor, when he's already said that, yes, they didn't tell me what to say, I'm going to try to avoid any possibility of the inference that they're now trying to argue, when I know that that's what they're trying to argue. I'm going to dispel it
But
because we got the-
you would think, if he says they put words in my mouth and I didn't say those things, there's something in there he's gonna say they told him, right?
No, because he explained that
So
the
you think
way,
if you go down every line, eventually you'll come to the conclusion, everything in there is what he said.
yes, what exactly
I'm
what
at
he.
the trial, back
what
at the trial
he
in
actually-
1995. I'm talking about when the
May
civil
I-
motive type thing here.
Yes, may I say-
I'm just not following that. I got it in terms of, now you look at it back then, but, when you got someone with intellectual disabilities who's on a stand and they make a statement like that, oh, you can attribute all kinds of things if you don't deal with it too specific. But if you deal enough, you can figure out he knows what he's talking about.
And the motive of the civil defense attorneys right now is to make sure that you can't attribute all kinds of things. They want to make sure that pin down exactly what the truth is, to pin down exactly that what he said generally, that they just disbelieved me, they just kept on telling me I was lying, that is all that they did. There's no trying to attribute all kinds of things if you go down and say, yes, they didn't tell me to say this, they didn't tell me to say that, they didn't tell me to say all these different things. There'd be nothing left for them to try to argue there's an inference contrary to his actual statement, which was that nobody told him what to say.
All right, thank you, Mr. Redmond.
Thank you, and I ask for the judgment to be affirmed.
Ms. Horn?
Yes, I want to start where we stopped, which is defense counsel providing very granular questions that the prosecutor should have asked. That's not anywhere in the case law. The case law talks about lines of inquiry that she should have examined. They identified several in their brief. We demonstrated that all of those were covered. And I picked out some quotes while he was arguing that address this idea of who said, she should have asked, who said what? Who told you to say what? Here's what she asked. Who was making you say stuff out of your mouth? That's one question. Okay, now you said somebody told you what you had to say. What did they tell you had to say? Another question. You said the police told you what to do. I want you to tell me exactly who told you what to do and what they told you to do. Another question. What exactly did the white detective tell you you had to say? Yet again, Marcus, when exactly did the police tell you what to say? Another question. Now, did the police give you a script and tell you exactly what they wanted you to say? This issue of who told him what to say, it was covered. And if the requirement under 804B were as granular as the questions they're asking, testimony would never qualify. It would never be able to be admitted under 804B1 because there's always going to be a question that you could have asked or you should have asked that doesn't get asked, but that doesn't change whether or not there were similar motives.
Ms. Horn,
That's
can I ask
separate.
you about that question about whether or not the district court, in your view, thought that that there was a per se bar on admission of this kind of testimony in a civil trial? Do you think the district court misunderstood the law?
I do think that the district court adopted by saying, the district court said, here's Hill, here's Fields, I find Hill more persuasive. If you look at what's in Hill, Hill is a categorical bar. Hill says prosecutors, they're there to do justice, they don't have the same motives as civil defendants, and the stakes are always different. Obviously, a prosecutor is trying to prosecute someone and convict them of a crime. A civil defendant is trying to avoid liability. That is a categorical bar. That is saying that.
Might one read that as suggesting that she found the facts in, is it Fields? Is that the first case? More analogous to the facts in this case, and therefore the same result should obtain?
No, Your Honor, I don't think that that's what she did, because one of the facts that she found was that it would have been a reasonable trial strategy, for example, for the prosecutor to have just cut her losses, got enough testimony to get the police statement in, and then got Marcus off the stand. That is kind of in the abstract, right? That's a sort of an abstract thought that could have been true, but it's not what happened here. That's saying that prosecutors have these, there are these ideas, there's these motives that prosecutors have that can never be replicated by the civil defendants. I don't think she was looking specifically at the facts of Hill or the facts of Fields. Frankly, they're very similar. In one case, in Hill, it was a deceased co-defendant, and in Fields, it was an unavailable witness.
You probably weren't even born or very young in 1995, but is there anything in the record to indicate where those detectives were during that testimony? In the courtroom? Or were they in the courtroom? Is there anything in the record? You probably don't know, but
The only thing
sometimes they're actually sitting there next to the counsel. Sometimes they turn around and talk, but there's nothing in the record to point to that, I take it.
The only thing I can say that's in the record is that when Marcus identifies the detective who told him what to say, he says that it's the white detective who was not in the courtroom at that time, I believe was outside the courtroom.
I see.
That's the only information that I have to answer that particular question.
Ms. Horn, Mr. Redmond began his argument with an assertion that your client, in fact, admitted his guilt in an effort to obtain parole, and you don't dispute that, but you characterize it differently. What is the relevance, if anything, about that admission?
I don't think there's any relevance at summary judgment about that admission. He did make a statement, he regrets obviously making it to get into the Patuxent eligible persons program. It is not true. And I wanted I think the fact that they're so focused on that particular piece of evidence really reflects that the defendant's argument, they still want the evidence to be taken in the light most favorable to them. The fact that it was so difficult, for purposes of summary judgment, these clients are innocent. They're innocent. There is ample evidence of their innocence. They certainly at a jury trial can contest that, but for our purposes here on appeal in this procedural posture, they're innocent and the evidence has to be taken in the light most favorable to them. And I just want to speak to, they didn't just have their writ of actual innocence granted, they actually got a certificate of error from the state of Maryland that indicates they are in fact innocent
What
of
does
this
that
crime.
mean, a certificate of error?
So currently, there is the Walter Lomax Act that provides a mechanism for which people can prove by, I think it's by a preponderance of the evidence, that they're actually innocent of the crime. Before the Walter Lomax Act was granted, the persons in that position would have to get a certificate of error from the state's attorney's office in order to pursue that line,
So,
pursue that avenue of relief, excuse me.
one question about that. It's true, isn't it, that the trial judge who granted the writ expressed some skepticism about it, but essentially, since the parties agreed, signed it?
The judge expressed some skepticism that the evidence was new, but if you look at, and Lauren Lipscomb, who was the head of the Conviction Integrity Unit, did testify in this case. There was an extensive memo that indicated that they found that there was substantial evidence of their innocence that came through both because of the number of alibi witnesses that testified on their behalf, all of whom were corroborated, but also because there were significant questions about Diane Bailey's ability to see what she saw, ability to hear what she alleged she heard, and the reliability of her testimony, which, as Detective Patton admitted at trial, was completely uncorroborated. They couldn't find crime scene evidence to corroborate it. They couldn't find a single witness to corroborate it. In fact, the eyewitnesses said not only that the shooting started in a different location that she admitted she couldn't see, but that there was one shooter, not four, and certainly not running, as I mentioned, up and down the street. The last thing, I know I'm probably running short on time.
No,
but
you're over your time.
I'm over.
So,
Well, if you'll
Very
indulge me, which is that, Judge Wayne, you said I think I'm very much paraphrasing you, you said if this isn't the kind of testimony that can come in, what is? And I think that is correct. You said, it's not their fault that Mr. King is unavailable, that he's not able to testify. And I would direct this court to this court's opinion, Sharon versus Crane Houdale International, I might be mispronouncing it, 47 F sub 3D 280. And I think that case really talks about this idea that it really extends the idea that this testimony is in fact more probative of anything else that's available because so many years have passed, 30 years have passed, so it would serve the interest of justice because the alternative is no testimony at all, and that is patently unfair and not in the interest of justice of this case and the vindication that these clients, the interest they have in vindicating their rights.
all right, thank you, Ms. Horn.
Thank you so much, I appreciate it.
I want to thank both counsel for their arguments this morning. We'll come down and greet you and adjourn court for the day.
This honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.